Thank you. Good afternoon. Welcome to Panel A, Medical Board of California, November 20th, 2024. We apologize for our delayed start of 1:20 p.m. today, and we would like to start with calling this meeting to order and establishment. We have a quorum. Thank you.
Dr. Bolot,
Here.
Dr. Helser,
Here.
Ms. Mitchell,
Here.
Ms. Torres, Dr. Saied,
Here.
Mr. Watkins. We have a quorum.
Thank you. And I'll move to item 2, which is the election of a panel chair and vice chair in accordance with BNP or Business and Professions Code Section 2008. And at this point, I believe that we can ask for nominations. Okay. Would anyone like to nominate? And can we do it together? Oh, go ahead. Sorry, Dr. Helser.
I nominate Dr. Bolot as chair.
Thank you.
Get that motion.
Thank you. And we need to vote then. All in favor, raise your hand, please. It's aye, it's unanimous. Thank you. 1, 2, 3, 4, 5, 5, 0. And second, we want to nominate our vice chair for panel A. May I have a nomination, please?
I nominate Dr. Saied as vice chair.
Do you want?
I second that.
Okay, we have a first and a second. All in favor of Dr. Saied as the vice chair of panel A, please raise your hands and say aye. Okay, 5-0 and opposed. Thank you. Congratulations, Dr. Saied. Thank you for the vote of confidence, members. Next, we have our oral argument following Superior Court reprimand for Dr. Kayvan Haddadan.
Do we have the court reporter ready?
Yes, Your Honor, I'm ready to go.
Great. So why don't we go ahead and open the record. We are on the record before the Medical Board of California, Panel A, Department of Consumer Affairs, State of California, in the matter of the accusation against Kayvan Haddadan, MD, Physicians and Surgeons Certificate Number A87957, Medical Board of California Case Number 800-2019-053650. OAH number is 2022-100-104. As it was indicated off the record, this is a Superior Court remand. So today is November 20th, 2024. It's approximately 1:24 p.m., which is the date and time. This was set for oral argument. Well, the time was 1 o'clock for oral argument in the notice of hearing for oral argument after the Superior Court remand. We are conducting the oral argument both in person and by WebEx video conference. My name is Julie Cabos Owen. I am an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument. For the record, it was just noted while we're off the record that there is a quorum. If I could just briefly have the panel members identify themselves going around the room just for the record.
Wendy Mitchell,
James Helser.
Michelle Bolot.
Veeling Sai.
Ezric T.J. Watkins.
And now if I could please have the appearances of counsel for the record, beginning with the Deputy Attorney General.
Good afternoon. Megan O'Carroll of the California Attorney General's Office on behalf of complainant and the Medical Board of California.
And Brian Taylor
for respondent Dr. Haddadan.
All right, for the oral argument, the following process and time limitations will apply. For respondent, 15 minutes of opening argument. The Deputy Attorney General, 15 minutes of opening argument. Then respondent and then the Deputy Attorney General both have 5 minutes of closing argument. It's my understanding these time limits will be strictly enforced. The arguments should be based only on the existing record and should not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but we will not be asking questions that would elicit new evidence. Either I or any panel member may ask a party to support the party's oral argument on the matter with a specific citation to the record. And then at the end of the oral argument by counsel, I will offer the respondent physician an opportunity to address the panel. And if he elects to do so, I will place respondent under oath. A court reporter is present to record the proceedings. And then after oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. All right. And again, please remember that arguments must be based on the existing record. I believe the board has already had the benefit of reading of the briefs. So we can commence with the oral argument, beginning with respondent.
Your Honor, I have one point of housekeeping matters before I start, if that could be heard.
Right.
I, having read the complainant's written objection, written argument, I had submitted to the two objections to claimant's written argument, and I would ask that those objections be sustained.
Let me take a look at those. What were the objections to the written argument?
Yeah, I made two objections. The first objection is that Ms. O'Carroll argued that there was patient harm, the probable patient harm. There was no evidence of that to support that inference. And in fact, the evidence was contrary to that. And that's an inappropriate inference to make without having some evidence of it. The second objection was related to Ms. O'Carroll's argument that another accusation was dismissed, and because it was dismissed, the very fact the accusation was brought should support discipline in this matter. And that's, again, I think another inappropriate argument to make.
In the underlying, just addressing your second objection, in the underlying, excuse me, in the underlying decision, proposed decision and adopted proposed decision, is there any mention in the evidence and in the facts of the proposed decision about the fact that the accusation was dismissed?
Yeah, it was part of the same overall decision. The two accusations had been consolidated into one. And so the decision does dismiss that second accusation. My objection is to the argument about the effect of that accusation.
Right. And then with regard to the first objection, I'm just reading your objection right now. All right, so the objection, both objections are overruled. It's my understanding that there's some parts in the record that may give rise to complainant, or excuse me, to the Deputy Attorney General's argument in this matter. So those are overruled.
Thank you, Your Honor.
And then did you want to proceed with your opening?
Yes, thank you.
All right.
I wanted to first thank the panel for their time and for their careful consideration of this matter. I also wanted to mention, I think we know that Dr. Haddadan is appearing remotely today. He's in Sacramento and had patient care concerns today he had to take care of, but he wanted me to express the importance of this hearing and this matter to him. And he is available if there is a question for him. He could answer those questions. We are here to discuss a new patient intake that occurred in March of 2014. Over 10 years ago and now almost 11 years ago. And in particular, whether an omission that occurred on that patient intake can support discipline when the accusation related to that omission was not brought within 7 years of the omission. It's actually about 8 years when the accusation was brought. The intake that we're talking about was a new patient referred to as patient 2 that was referred to Dr. Haddadan from the patient's primary care physician. Patient 2 suffered and still suffers, unfortunately, from chronic back and knee pain. The referral was to Dr. Haddadan, a pain specialist, and to assess the patient's chronic pain. While patient 2 was new to Dr. Haddadan, patient 2 was not new to opioids and was not new to methadone. So when the patient came to Dr. Haddadan in March of 2014, the patient was already taking 60 to 70 milligrams of methadone a day and had been doing so for many years. Patient 2, by the way, is a rather sophisticated patient. He's a prominent attorney in Sacramento, an educated, I'm not saying necessarily educated in medicine, but an educated person who you can assume with his position can communicate well and understand what's being communicated to him. And he reported to Dr. Haddadan that he had a prior EKG ordered from his primary care physician and that EKG was normal. And he also reported to Dr. Haddadan that he had no history of cardiac issues. Based on this information, in totality, in Dr. Haddadan's assessment of the patient and the information that he'd been on methadone and no cardiac issues, and a prior normal EKG, Dr. Haddadan continued patient 2 on the same level of methadone. And he did not order an EKG, deeming it unnecessary. We can set aside just for a minute whether the standard of care actually required all patients starting on methadone to have an EKG. And we can set aside whether a pain specialist like Dr. Haddadan has discretion whether to order one or not in that circumstance. But what we cannot set aside is that if that was a mistake, if that was an omission, that omission occurred in March of 2014. That alleged omission occurred more than 10 years ago, and more importantly, it occurred more than 7 years prior to the filing of the accusation in this case. Business and Profession Code section 2230.5 provides, and I'm going to paraphrase a little. Any accusation filed against a licensee shall be filed within 3 years after the board discovers the act or omission alleged, or within 7 years after the act or omission alleged as the ground for disciplinary action occurs. whichever of those occurs first. Here, if there was an omission, it occurred in March of 2014, 8 years before the filing of the accusation. Now, Ms. O'Carroll, the Deputy Attorney General, argues that the failure to order an EKG is a continuing violation, meaning that every time Dr. Haddadan saw patient 2, which is on a monthly basis, that was a new violation. And therefore, the violation continued even through maybe today. The evidence did not establish that. And the decision already rejected that concept. The decision stated, and this is a quote, "The evidence did not establish that the standard of care required respondent to conduct periodic EKG testing of patient 2, either as a matter of required routine or based on patient 2's clinical circumstances." Therefore, had Dr. Haddadan ordered a baseline EKG in March of 2014, there was no requirement to order an EKG after that, no periodic or no annual. So there was no obligation for him to go back at some future time and go, well, we need to order another EKG. The omission, if there was one, again, occurred on March 28, 2014, when Dr. Haddadan decided not to order an EKG based on those totality of facts when he assessed that patient. Ms. O'Carroll's position that an omission that occurs at the initial patient intake is a continuing violation would vitiate the effect and the purpose of Business and Profession Code 2230.5. Because it would make every omission that occurred on the patient intake prolong and live on throughout the time period that the physician saw that patient. So every patient visit after that initial visit would necessarily suffer from the fact that there was an omission in the original history and physical. Such a position would make those omissions perpetual. As long as that physician continues to see the patient, you would have to go, well, you forgot on that day one, 10, 15, 20 years ago, to do some test or to take some piece of information. And that's what 2230.5 prevents. It's within the wisdom of the legislator to make that decision. We may not like that rule, but there's a policy that has been adopted by the legislature of the state of California that is the best course. That we're not going to audit physicians back 10, 20 to the beginning of their practices and go, we're going to go through all your patient medical records and see if you forgot something. It would also extend the practice of keeping patient medical records beyond, well, there's no absolute standard for that, but typically it's 7 to 10 years. Such a requirement would require you to keep that initial intake in perpetuity, again, as long as you're seeing those patients. That just cannot be the rule. I want to spend a minute to discuss the lack of evidence that an EKG is required in all circumstances. The medical board's expert, Dr. Chong, cited only the 2007 medical board pain guidelines and the 2014 pain guidelines. The 2007 guidelines were never actually produced by Dr. Chong, although he cited to them, and they were never presented in evidence, and they're not in evidence. And it's reasonable to assume that they don't speak to EKGs. With respect to the 2014 guidelines, they came out at the end of 2014. So they came out about 8 months after Dr. Haddadan first saw patient 2. But the medical board pain guidelines even if you could apply them retroactively back to when Dr. Haddadan first saw the patient. They're guidelines. They are not standards. And they state so at the beginning of those guidelines, that they do not pretend to even state the standard of care. Dr. Chong, while relying on the medical board guidelines, he dutifully recites the standard of care from in legal terms. But when he actually testifies, when he takes that legal definition and applies it to what we're talking about, EKGs, he testified that, and this is a quote, and then I can give you the page line from Dr. Chong. So in terms of medical board guidelines, I'm trying to determine if those guidelines were met at a minimum to determine if there was or was not a departure in the care. And that's simply wrong. That's simply wrong as a matter of law, that the standard of care is the medical board guidelines. The standard of care, as you all know, is not set by the board, with due respect to the board, but rather is defined as the level of skill ordinarily possessed and exercised by other reasonably careful and prudent physicians in the same or similar circumstances at the time in question. And Dr. Chong did not apply that standard. But when we look at the 2014 guidelines, even if we get past all that and go, okay, do these guidelines set some bright line rule? A bright line rule that if you're starting a patient on methadone, you must order an EKG. And when you read the guidelines, you go through all the body of it, and there's no mention of EKGs at all. It's not till you get to page 51 of the appendix, page A51, it does say something about EKGs. And here's what it says. And this is a quote. Although uncommon, potentially lethal cardiac arrhythmias can be induced by methadone. The cardiac health of patients who are candidates for methadone should be assessed with particular attention paid to a history of heart disease or arrhythmias. An initial ECG may be advisable prior to starting methadone, particularly if a patient has a specific cardiac disease or cardiac risk factors or is taking agents that may interact with methadone. So the key phrase there is may be advisable. May be advisable is not a bright line rule. It is not a mandate. No other evidence was presented to support that EKGs must be ordered in every case. No articles, no peer review studies, case studies, continuing medical education materials, textbooks, nothing supports Dr. Chong's opinion. All the evidence produced supports the opposite conclusion, that there was no consensus on when EKGs are required for a patient starting methadone. For example, Exhibit O was presented. It was the California Medical Association's publication in May of 2014 regarding use of opioids. So this came out just 2 months after Dr. Haddadan first saw patient 2. The CMA states in May 2014, an initial ECG may be advisable prior to starting methadone, particularly if a patient has specific cardiac disease or cardiac risk factors. So they basically, their language was what was adopted by the medical board later in 2014. So the two pieces of information that we have that came out in 2014 both say may be advisable. It's not a mandate. We presented a number of articles from the relevant time period that go back prior to when Dr. Haddadan saw patient 2. Those articles are found at exhibits Q through T. And in particular, I would ask you to look at exhibits S and T, both of which include a summary of recommendations by various expert panels. Those recommendations regarding when an EKG should be provided vary greatly. In fact, they vary from you should do it from all patients to start to another expert panel saying it's never necessary. Most of them seem to fall in somewhere in the range of, well, when you start a patient on methadone, if they're on a high dose, which seems to be somewhere above 120 milligrams a day, that you may consider that, especially if they have these history of cardiac issues. But there certainly was no consensus at that time. And then there's no consensus to this day, but there certainly was no consensus for a provider in 2014, seeing the published materials, that an EKG was required in all instances.
Counsel, you have about 10 seconds left.
Okay. Well, I'm just going to say this, and it'll take me 5 seconds longer than that maybe, but so when you are talking about bright line rules, there is no bright line rule regarding an EKG. But what is a bright line rule? The bright line rule is shall is a bright line rule. And B&P code 2230.5 says an accusation shall be brought within 7 years of the omission. Thank you.
Thank you, counsel. All right, and then argument from the Deputy Attorney General.
Yes, Your Honor. Good afternoon, board members. This matter comes before the board on remand from the Superior Court with a single question for the board to answer. And that question is, does the statute of limitations prohibit the board from finding that respondent was negligent in failing to obtain an EKG of patient 2? Now, if the board answers that question no, as I strongly argue here today is the correct result, then you can simply add a few clarifying words to the decision and finalize the matter once and for all. However, if you determine that there is a statute of limitations violation, then the matter would have to be dismissed because there's one of two grounds for repeated negligent acts, and of course there must be two. Now, as I will explain, that would not comport with the evidence presented at hearing or the decision and the import of the decision, and therefore I strongly encourage the board not to do that. So diving into that statute of limitations issue, I'll first present a kind of set the table as to what the facts were for the board to work with. Patient 2 began seeing respondent in 2014 for knee and back pain. That will be found in the record in front of you that you have. There are 3 portions of the record. There's the transcripts, there's the confidential portions of the record, which I'll refer to as the sealed confidential record, and then there's the open OAH records, which I'll just refer to as the OCR, the record on appeal. So the portion where the 2014 for knee and back pain as to patient 2 is from the confidential records at page 1407 and page 1624. And in fact, what I will do is I will, except when it's significant, I will assume that there's a good faith understanding of what the record is. However, I'm prepared to provide the record if requested, but I won't say in each case where it can be found in each of the records unless requested, in which of course case I will. However, before continuing with these facts, I do want to address one point, and that is the reason it's so important to refer to the record is because there's always a danger when attorneys speak that they would misstate the record. And unfortunately, there was one point that I must raise immediately in the respondent's argument that I must address that would, if in fact true, perhaps cause a problem with the decision and make it unsound. And that is respondent's counsel previously said that Dr. Chong failed to establish and use the appropriate definition of standard of care in his testimony. He cited to one portion of the record where Dr. Chong was asked about the interplay between the standard of care and the guidelines. And he did say, yes, he looks at those guidelines as a foundation point, which of course is natural and appropriate. However, what was omitted, and which is the most significant part, is in volume 1 of the transcripts at page 66, Dr. Chong was asked to state what is the definition of the standard of care. At lines 19 to 22, he stated that it is, and I quote, the standard of care is the skill level, knowledge, care to manage a patient that other reasonable providers, physicians would use during a similar circumstance at that point in time. Therefore, as I was saying, it's very important to cite the record accurately, and I will endeavor to do so during my argument here. So patient 2 began seeing respondent in 2014 and continued seeing him between 2014 and 2020. During that entire 6-period time, respondent prescribed between 60 milligrams and 70 milligrams per day of methadone to patient 2. That can be found in the confidential records at page 1625. Now, despite this, respondent never performed an EKG to monitor patient 2 for QT prolongation throughout the entire period of 6 years. That can be found in volume 1 of the transcript at page 127, and again at 1627 of the confidential portion of the transcript. At no point, as I said, did respondent ever order an EKG for patient 2 or obtain a copy of any other EKG that patient 2 may have had with other providers. And he did this despite the fact that he continued to prescribe methadone to him during that entire course of treatment. And again, that's at page 1627. Now, the board provided expert testimony from Dr. Chong, who is in fact a fellowship-trained pain management provider, the only fellowship pain management provider who testified before the board. And in fact, Dr. Chong is in fact board certified in PMR medicine, physiatry, which is the same specialty as respondent. Again, respondent's expert was not board certified in that. Neither was he fellowship trained. So Dr. Chong explained that methadone is known to cause abnormal cardiac rhythms, even in people who don't have a previous history of that. And that's what makes it so dangerous, because those rhythms can cause sudden death out of the blue, even in patients who don't have previous cardiac symptoms or problems. In fact, this phenomenon is so well known, as Dr. Chong explained, that the FDA has placed a black box warning on methadone, informing the public of that risk. And that can be found at volume 1, page 127 to 28, as well as page 133 of Dr. Chong's testimony. Now, the risk of arrhythmia increases with an increase in the dose of methadone. Dr. Chong testified that the standard of care when treating patients with methadone for chronic pain is to obtain an initial EKG and to repeat it periodically over the course of treatment in order to monitor the patient. Respondent's expert, however, testified that that's not necessary, that the standard of care, despite the black box warning, does not require this simple, inexpensive, and non-risky test. Although he did admit in volume 3, page 128 of the record, that he in fact performs EKGs on all of his own patients to whom he prescribes methadone. Regardless of this, he testified that in respondent's case, it was okay for him not to perform an EKG because the patient 2, had verbally told him by word of mouth that he had received an EKG and that it was normal. He didn't have any heart problems. Although again, none of this was ever provided in writing to Dr. Haddadan, to respondent. Never did respondent contact any of the other providers to confirm that or obtain documentation of that. Now, the decision, rather disappointingly in my view, but it is what we're stuck with, it met both of the opposing decisions in the middle. So it declined to adopt wholesale Dr. Chong's testimony that patients receiving methadone require an EKG to each one, or that it should be performed each year. However, it did conclude that patient 2, who was on a moderately high dose of methadone, required at least some kind of a baseline EKG for a physician to be prescribing him this continuous moderately high dose of methadone. I understand that many physician members of the board may find this concerning or surprising, given that Dr. Chong's findings are, opinion is pretty orthodox that you should do an EKG regularly on patients receiving methadone. However, it is what the ALJ decided, and that is not something that we can revisit. Neither side can, we're stuck with that. I strongly argued that that should be different, but this is where we're at. So although we may feel that the administrative law judge is being extremely lenient, it is the finding that we have. So the question here is, the point, however, is it doesn't even really matter whether we think it should have been higher or lower. And the reason it doesn't matter to the resolution of this case is because the problem for respondent is that he never got an EKG of patient 2 or got any kind of a written copy of an EKG. So over the entire 6 years that he treated him with methadone. Now, the board's decision, which adopted the proposed decision of the ALJ, found that respondent was repeatedly negligent for failing to order an EKG test for patient or to note a review of a recent EKG. And this is found at the decision at paragraph 10 under the legal conclusions. Now, during the writ proceedings before the Superior Court, respondent argued that this finding by the board violated the statute of limitations. Which, as you know, requires that a claim be brought within 3 years of learning of the negligent acts or 7 years of the event. Respondent's argument is based on the fact, as he just stated, that when he began treating respondent in March of 2014, and that because the accusation was filed in March 11 of 2022, that he began seeing patient 2 more than 7 years before the accusation was filed. So his argument asks the board to agree that that respondent is being disciplined for conduct that occurred solely in March of 2014, and the only reason the reason he cited for that was he pointed to paragraph 67 of the analysis portion of the decision, where he noted that petitioner failed to order an EKG test or review a recent EKG test of patient 2 when he began treating him with methadone. But the problem with this is that to interpret the phrase in that manner, the board would have to take that one phrase out of context and ignore the rest of the evidence in the record showing that respondent never obtained an EKG of patient 2, either in March of 2014 or at any time in the succeeding years during which he treated patient 2. Respondent is disregarding the fact that his failure, while it may have begun outside the statutory period, did not evaporate after the first few months of his treating patient 2. Rather, it was a continuing violation that continued well into the statutory period. The board's decision already makes it clear that that was not the intent of the analysis. For example, at page 48 of the decision, at paragraph 48 of the decision, it describes that petitioner saw patient 2 from 2014 through 2020, and that throughout that time, he was prescribing 60 to 70 milligrams of patient 2. It goes on to point out that the records do not show petitioner ever ordered or reviewed an EKG for patient 2 during the entire time of treatment. Further, it should be noted that paragraph 65 states, Dr. Chong's opinion is persuasive on the point that the standard of care requires a physician treating patients with methadone to obtain at least an initial EKG to establish a baseline. So respondent's argument would ask the court to conclude that because respondent failed to obtain that baseline during the first 10 months of his 6-year treatment with patient 2, that he can evade responsibility to ever establish that baseline throughout the next several years of treatment. And that is what there's no evidence to support. There's no evidence to support the contention that not obtaining an EKG initially when treating a patient equates to a free pass to never obtain that baseline. So it would be like saying that if you treated a patient for 6 years and you never tested their level of their blood sugars, that's okay because, well, you didn't do it during the first year. So why would anyone ever need to find a blood sugar at any point thereafter when you're treating the patient? The risk does not evaporate, and therefore the violation does not evaporate. And that is a significant point that the board should consider. So in order to resolve this, the board can fix the issue with the rather inaccurate wording of the administrative law judge by adding 5 simple words to to a sentence in paragraph 67 of the decision. And that would be where it says in paragraph 67, petitioner failed to order an EKG test or review a recent EKG test of patient 2 when he began treating him with methadone. The board can simply add 5 additional words after that or at any point thereafter. By adding these 5 simple words, it will eliminate the statute of limitations problem and reject the unreasonable interpretation that respondent is asking the board to make, and it will dispense of the statute of limitations question. So again, I would propose adding those state words or at any point thereafter to that sentence in paragraph 67. So even taking this case in the light most favorable to respondent, which I believe the administrative law judge really did. He didn't find, for example, extreme departure for disregarding the methadone, the methamphetamine test of patient 1. However, he did find it to be a simple departure. And as I stated, in order for the discipline to be sustained in this case, there has to be 2 simple departures. So the one would be with patient 1, which is a simple departure for failing completely to address a positive methamphetamine screen in a patient to whom he was providing opioids. And then the second one would be failing to obtain an EKG of patient 2, either when he began treating him or at any point thereafter, despite prescribing methadone to him. And that will make the decision safe and insulated from the statute of limitations argument and will protect the public, which is the board's highest priority naturally, and will comply with all the legal requirements to establish the grounds for discipline in the original decision. And that's what I would urge the board members to do.
Thank you. And your time just expired. Thank you, counsel. All right. And then is there anything by way of closing from, well,
Yes.
okay.
Yeah, thank you. So first I want to state is I did not misstate Dr. Chong's testimony. Earlier I stated that he dutifully recited the legal standard, and then he went on to, with respect to EKGs, he went on to say that he looked to the guidelines to see if those guidelines were met. And so what Ms. O'Carroll read to you is what I told you, the dutiful recital of the legal standard. The very next question and answer that starts at the bottom of page 66 and on to 67 is what I read to you. So, but what I want to really address is this idea that Dr. Chong got it wrong and got it allegedly right, according to the ALJ. And that should be concerning to all of you, because what Dr. Chong did is he said you need an initial and you need a periodic testing, and he provided no support for that. There's nothing you can look to for that. And so the ALJ goes, well, you got it wrong on the periodic part. You don't have to have periodic EKG testing. But he says you're convincing on the initial that you have to have an initial baseline. And I don't know how you get there. You just determined that the guy was not convincing on a periodic, but you think he's convincing on the initial baseline. If there was something to support that, it would be interesting. There was some article or some news thing or some, medical school journal, something like that. It would be an interesting question, but it's not. There's not. There was nothing in the evidence to support that. But it still begs the question. Ms. O'Carroll's saying, well, it's like if you didn't order a blood sugar at the start, then that doesn't mean you never have to get a blood sugar test. The problem with that argument is that it was already determined here that there's no obligation to get any periodic EKG, either in general or for this particular patient. So you didn't have to go get another test in the future. What you had to, if it's true that the standard of care required that initial EKG under these circumstances, with the patient reporting what he That mistake, that failure to get the baseline was that initial visit. Because the next visit, the standards, like, you don't have to have a new EKG. And after that, you don't need an EKG. 2 years down the road, you don't need an EKG. And so if there was a mistake and if there was an omission, it happened in March of 2014. And it is outside the period of time. And on those grounds, the accusation should be dismissed. Thank you.
Thank you. All right, and then for the Deputy Attorney General, anything?
Yes, Your Honor. So regarding the question of whether there is support for the contentions, for the basic argument that a physician should not be prescribing methadone blind, in other words, without ever having obtained an EKG, the answer to that is pretty clear. Number one, if we needed to look for any more support in the record, I think probably what would be most persuasive, especially particularly to physicians, is the evidence in the record that I cited, which shows that there is a black box warning on methadone, stating that it has the potential to cause serious arrhythmias and sudden death in patients. And that is exactly what Dr. Chong's testimony established. And what the ALJ responded to when he agreed, you cannot prescribe blind. At bare minimum, there must be some EKG in order to prescribe. The only question is whether or not that obligation just poof evaporates and goes away. If you made the mistake in the first year, does that mean you get a free pass on making that mistake ever after or not? Logically and reasonably, that of course that there's no real question. If there's a cheap and easy test to prevent patient harm, why on earth would there ever be some kind of legal standard of, there's no legal argument that makes any kind of common sense to make that evaporate. So trying to argue against common sense is a hard place to be, and it just doesn't work. Second of all, regarding the articles, I think it would be very interesting for the panel members to review some of those articles, which incidentally Dr. Chong described and addressed very thoroughly in his testimony in volume 1. For some reason, they did not end up being something that the administrative law judge chose to address. I wish he would have in the decision, because as Dr. Chong explained, a lot of the reason why there isn't very good, like these articles say, well, there's no real confirming evidence as to whether or not getting EKGs means that patients are at any greater risk. Dr. Chong explained there's a good reason why there is no such evidence about that, because you'd need to have a control group, and it would make absolutely zero medical sense to have one group of patients that you give EKGs to and the other not, and see how many die. That would just be horrifically unethical and inappropriate. Also, many of the articles referred to by respondent were articles addressing patients who are receiving methadone as part of addiction treatment. So the argument that many of the authors there were making is don't prevent getting patients who are at risk, serious risk of heroin, don't prevent them from getting on methadone treatment just because you might not be able to get all of them in for EKGs. But please don't take my representations of these articles. I encourage you to look at those articles yourself and see if they make sense. I would urge that they do not, and that what does make sense here is common sense, and particularly with regard to the the prescribing guidelines. It is inaccurate to say that the guidelines contain no reference to the importance of obtaining EKGs when prescribing methadone. As respondent did point out, the appendix does specifically refer to specific examples. Obviously, the prescribing guidelines are meant to be short and concise, but they can provide more detail in the exhibits and attachments. And in page 51 of those appendices, I'm not sure, you will see the reference to the importance of monitoring patients on methadone with EKGs. Because as Dr. Chong explained, it's cheap, it's easy, it saves lives. And for that reason, whether you obtain it the first day you begin treating a patient, whether you obtain it, you forget to do that and you obtain it as soon as you can thereafter, great. I mean, the goal here is to meet the standard of care and prevent patient harm. But the argument that because you made a mistake for the first year that you can continue making that mistake again for the next 5 years of treatment with impunity, that's just not going to work. And for that reason, I urge the board to reject the the statute of limitations argument and correct and maintain the decision, which the Superior Court's order of remand specifically provided the board an opportunity to do. I urge the board to take that opportunity.
Right. I did not address this during the pendency of the arguments, but was there any board member who had any questions to clarify anything in either of counsel's arguments? And if so, if you wanted to just state your name and your question. I'm not hearing any questions. I would typically offer the respondent physician an opportunity to address the panel under oath. Counsel, is your client wishing to address the panel?
He is here. I don't know. Let me see if he's communicating with me via text. I haven't heard anything from him, so I don't know that he has anything to add. It's, I think, fairly well established in a legal position, legal argument principally. So, well, he's texting me now. He does have something to say.
All right. So do we have the ability to have his camera turned on?
Dr. Haddadan's with us. He can go ahead and activate his camera and he'll show up here on the screen.
Can you
Dr.
hear me?
If you could do the start video like we did before the meeting started, that'll make you appear. Perfect. Thank you.
All right. Doctor, if you could please raise your right hand and be sworn in. Do you solemnly swear the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And Doctor, what did you want to tell the panel today?
A few things that was argued. First of all, I was trained in the era that methadone was a drug of choice. It was 2005, and then 80% of the patients at that time, when we had any problems with other medication, we would start on methadone. If I wanted to send all of them to EKG, my EKG from my practice going out would exceed the cardiologist request for EKG. There's a bunch of articles that we provided that says that EKG is needed only for a high dose over 100 milligrams and above. This patient was on methadone for 5-6 years prior to coming to me. Number one, he had EKG with the primary care physician. Number two, he didn't have any risk factors that make me even think that he needs EKG. And the black box that is talking about, even Tanolol has a black box for liver enzyme, liver failure. We don't go routinely send all the patients for liver enzyme check if they're on Tanolol. There should be a sign that the patient says, I have heart issues, I have something that makes me think that the EKG would be necessary, which I have done it for the other patients, and the panel, the records is reviewed, and it was obvious that I know the EKG was required for the patients that have a significant history of being on methadone. That's the other thing. This patient still isn't my patient. The thing that Ms. O'Carroll didn't mention was that from the day number one, this patient was put on a tapering dose of methadone. Right now, he's still my patient. We have done the EKG, and there's no symptoms of no problems in the EKG whatsoever. And is on 20 milligrams of methadone. We continuously taper the medications down, which is another thing, that there's no harm done on this patient or any other patients that I did or did not do EKGs. The analogy of blood sugar doesn't pan out. You don't randomly do the blood sugar for anybody. There should be a symptoms that makes me think the blood sugar is high to do the send the blood sugar. This patient It's a strong heart. There's no problems with the heart. EKG was done before. It didn't feel, and the patient was on methadone for 5 years prior to coming to me, and I tapered the patients down. All these factors are just a matter of the opinion that they want to discipline a doctor who's providing pain services for most complicated patients in the community to get my reputation down and get me agitated. I don't know what the purpose is for the medical board to do such a thing. For a patient, for a physician with my record and reputations, that I have not harmed nobody, including those 2 patients. Thank you.
Thank you, Doctor. I should again mention that we can only consider the evidence that was previously in the record. So if there's anything that was mentioned,
No, it was
that,
not, all of this in the records. The other thing that I forgot to mention, the sudden death issue that she mentioned, we provided article is in the record that sudden death rate for the patients on methadone is equal to the public, normal public. There is no difference between sudden death rate of the patients on methadone with patients that are not on methadone. That's also article was provided. Thank you.
all right, I believe we have all the arguments submitted. Let me just double check. And all right, so that concludes the arguments in this matter. The record is closed and the case is submitted for decision. We are off the record in this matter. And then the panel will be deliberating either in closed session now or at the conclusion of what I believe is another scheduled hearing.
Thank you, Judge Owen. Thank you to the panel. Appreciate it.
Aye.
Just is there going to be closed session following each oral argument or at the conclusion?
Your Honor, we'll go into the next oral argument and then have closed session.
Let me get my notes on that.
Okay, board members, we think we'll go forward with the what would have been a 150, now a 216 oral argument on non-adopted proposed decision. Last name of the physician is Kamali, Saied. And thank you, Your Honor.
Thank you. Let me, oops. Sorry, I'm just getting my notes. Apologies. All right, and do we have all the parties present? Okay, there we are. All right, so we are going to go on the record now. We are on the record before the Medical Board of California, Panel A, Department of Consumer Affairs, State of California, in the matter of the accusation against Seyed Kamali, apologies for the pronunciation, MD, Physicians and Surgeons Certificate number A77562. Medical Board of California case number is 800-2021-075-649. OAH number is 2022-110232. Today is November 20th, 2024. It is approximately 20:20 p.m. This matter was scheduled at 1:50 p.m. We're starting just a little bit later. And this was the date and the time was 1:50, set for oral argument in the notice of hearing for oral argument after non-adoption of a proposed decision. We are conducting the argument in person and by WebEx video conference. My name is Julie Cabos Owen, Administrative Law Judge with the Office of Administrative Hearings, and I have been assigned to preside over the oral argument. And for the record, while we were off the record, I did note that there is a quorum, but just for the record, if I could have the panel members identify themselves, please.
I'm sorry, Judge Cabas-Owens. We're looking for the respondent's attorney at the moment.
Oh, I apologize. I thought he was sitting at the table.
But I don't any longer. And yeah, I think we thought one was going to be in person, but
Oh, okay. Yeah, I saw counsel sitting and I assumed that there was another counsel there. So why don't we go off the record? All right. Are we trying to get him
oh, we
on?
believe he's outside of the hearing room. Please
Oh,
give
okay.
Okay,
a minute.
Your Honor. He's just arriving, Your Honor.
All right, wonderful.
I didn't know what time we should come in. We didn't want to disrupt.
Mr. Ray, jumped the gun. I called the case, so I'm just going to very briefly go through the case info for you. All right, are you set?
Yes.
All right, let's go back on the record. All right, we have located Respondent's Counsel. I just informed him that I called the case already, noted the case name, case number, and that the date is November 20th, 2024, and that this matter was set for oral argument after non-adoption for today at 1:50 p.m. We're getting a late start. And I don't know if you can see me on the screen, but this is Julie Cabos Owen, Administrative Law Judge with the Office of Administrative Hearings, assigned to preside over the oral argument. And I was just asking the board members if they could, for the record, identify themselves, so we have that on the record.
Wendy Mitchell.
James Helzer.
Michelle Bolat.
Veeling Sai.
Ezric TJ Watkins.
And as I had previously noted, there is a quorum. And now if I could get the appearances of counsel for the record, beginning with the Deputy Attorney General.
Good afternoon, Your Honor. Deputy Attorney General Leanna Shields.
Good afternoon. Oh, sorry. Good afternoon, Your Honor. Fred Ray, and I am here with Dr. Kamali.
All right. And I'm just going to go through this. For oral argument, the following process and time limitations will apply. For each first respondent and then the Deputy Attorney General, you have 15 minutes of opening argument. And then each, beginning with respondent, will have 5 minutes of closing argument, and the time limits will be strictly enforced. The arguments should be based only on the existing record and should not exceed the scope of the record of duly admitted evidence. So no new evidence will be heard. The panel members may ask questions of the parties to clarify arguments, but may not ask questions that would elicit new evidence. And either I or the panel member may ask a party to support their oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer respondent physician the opportunity to address the panel. And if respondent elects to address the panel, I will need to place respondent under oath. A court reporter is present to record the proceedings. And then after oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. And again, please remember that all arguments must be based on the existing record with no new evidence to be heard. All right, so I'm going to go ahead and start with respondents' oral argument. And you can proceed, Mr. Ray.
Thank you, Your Honor. Can you hear me?
Yes.
Thank you. I'd like to thank everyone for giving us this opportunity today. I'm a little rusty at appearing in person in front of in a proceeding, so I apologize for not coming in earlier and delaying you for a few minutes. As far as I know, the medical board is the only licensing entity in California that gives the opportunity for oral argument. So it's a privilege to have the opportunity to not only submit written argument, but to come in and talk about the case and to give you the opportunity to meet my client and to ask him questions if you wish to do so. Getting to my argument, the declared intent of the board's disciplinary statutes is to protect the public. That's under Zabedian versus Medical Board. Business and Professions Code Section 2229, importantly, states that the board, in exercising its authority, shall take action that is calculated to aid in the rehabilitation of the licensee, and if a restriction on the scope of practice is indicated, to order restrictions as are indicated by the evidence. The clear language of the statute requires an evidence-based approach to the terms of discipline. The board's Manual of Model Disciplinary Orders and Disciplinary Guidelines provides at page 1 that these guidelines are not binding standards. For changes to the suggested terms, the guidelines only require that any proposed decision or settlement that departs from the disciplinary guidelines shall identify the departures and the facts supporting the departure. Under Government Code Section 11425.50b, where the factual basis of a decision is based substantially on the credibility of a witness, the statement shall identify any specific evidence of the observed demeanor, manner, or attitude of the witness that supports it. In considering the testimony from the hearing, let's begin with Dr. Amador. The administrative law judge found the board's expert, Dr. Amador, credible and relied upon his findings. In the proposed decision, the administrative law judge noted at page 12 that Dr. Amador pointed out mitigating facts. This is the board's expert. For example, that it is not uncommon for another anesthesiologist to take over another patient's anesthesia, or that procedures are sometimes canceled so medication is pulled that is not necessary. ALJ Levy notes that Dr. Amador did not notice any pattern of medications that Dr. Kamali did not return, so no pattern would indicate drug abuse in his experience. Dr. Amador did not find any issues with patient care, just simple departures due to record keeping. Further, Dr. Amador commented in his report that anesthesiologists like respondent can have significant difficulty accurately interacting with medication dispensing and medication record systems, that a lack of familiarity or training can result in documentation errors, and importantly, Dr. Amador noted that it is common for anesthesiologists to have errors in their documentation. This is in the proposed decision at page 9. Judge Levy notes at the top of page 21 in the proposed decision that Dr. Amador's testimony is found persuasive in all respects. His conclusions are supported by the record and are unrefuted. He testified in a clear, dispassionate, and thoughtful manner. Judge Levy outlines extensive mitigation and rehabilitation evidence in Dr. Kamali's testimony. At page 18, Judge Levy noted that respondent understands that the board's concerns. He recognizes he needs to be more vigilant in his documentation going forward. Based on his history, he said he can practice safely. He has had no complaints about the care he has provided and has done the most difficult cases. Judge Levy found Dr. Kamali credible, as noted on page 18 of the proposed decision. On page 26 of the proposed decision, Judge Levy applies the rule articulated in the board's disciplinary guidelines at page 1 and Government Code Section 11425.50 and speaks to the board as follows. After considering the board's guidelines, evidence of mitigation, and the evidence of the record as a whole, it is determined that a public reprimand with the conditions that respondent successfully complete education courses and a medical record-keeping course would serve the interest of public protection. Judge Levy goes on to say, this conclusion represents a departure from the recommended guidelines. This departure is warranted because mitigating factors exist that explain respondents' failure to document the administration and wasting of the controlled substances. In detail, Judge Levy articulates the factual bases for the departure, beginning at the bottom of page 26 of the proposed decision. He notes at the middle of page 27 that Dr. Kamali credibly testified in his testimony about his lack of familiarity with the Omnicell dispensing machine and his problems using it to document the wastage of medications. With respect to the single pill of his mother's Vicodin that Dr. Kamali took, Judge Levy found that Dr. Kamali acknowledged his mistake, that there is no indication of a substance abuse problem, and that Dr. Kamali was transparent at his hospital when it first came up in his board interview and cooperated with the board in all respects, including voluntarily submitting to physical and psychiatric examinations, which were passed. In considering your decision, I would like to direct you to Respondent's Exhibit A, Letters of Recommendation, specifically a letter from John Kamali, Dr. Kamali's older brother. In Preston versus State Bar, 1946, 28 Cal 2nd 643 at page 650 to 651, the California Supreme Court held that the favorable testimony of acquaintances, neighbors, friends, associates, and employers should weigh heavily in the scales of justice. Dr. Kamali's brother writes that after Dr. Kamali finished his residency at Harvard, he was offered a faculty position at Harvard University Teaching Hospital at the time. However, Dr. Kamali decided to move back to California to be closer to his family. John Kamali recounts that Dr. Kamali decided to work part-time when their mother's health took a turn for the worse in order to help for her care. You see, Dr. Kamali's father was killed in a car crash, leaving his mother widowed and alone. Dr. Kamali's mother is elderly, suffers from severe spinal stenosis, has had a bilateral knee replacement, and due to her instability in getting around requires care. For this reason, Dr. Kamali was working 2 weeks on and 2 weeks off as a locum tenens anesthesiologist so that in his 2 weeks off he could relieve his brother from the care of their mother. This unusual schedule impacted his ability to reconcile medication records. John Kamali, Dr. Kamali's brother, wrote, "As a family, we felt that we would take care of the responsibility of taking care of our mother. It should be in priority position since she was refusing any third-party help to be with her at home for her care. My brother, Dr. Kamali, has been an integral part of managing our mother's medical care, along with providing daily support, a blessing all around due to her difficulty with her mobility." In his conclusion, John Kamali writes, "In closing, I want to mention that knowing and raising my brother personally, since my father got killed in a car accident when my brother was only 10 years old, and knowing him well, he does not drink alcohol or smoke. He does not even drink coffee. And that is how clean he is and believes in good health, a good health mentality. I hope you take this information coming from me as his older brother and acting as his guardian in his youth time." Complainant argues that the board should substitute its judgment for that of the administrative law judge who heard the case and conclude, without hearing the testimony of the witnesses, that the mitigation presented by respondent falls far below what is necessary to warrant a reduction to a public reprimand. With a record so replete with mitigating evidence, I cannot imagine what additional evidence would meet the standard of a downward departure, unless the evidence were so lacking as to support a dismissal. The board, through voluntary psychiatric and physical examinations, testing, and investigation, ruled out substance abuse. Even the board's own expert noted that record-keeping issues occurred with a range of medications which would be inconsistent with diversion, and gave many reasons why medication reconciliation errors, while being errors, do occur for anesthesiologists in general, and specifically in the case of a locums tenens anesthesiologist. The unique facts of the case explain why there were medication record-keeping errors in Dr. Kamali's practice at this hospital with its Omnicell units, why such errors are not unusual for anesthesiologists according to the board's own expert, and why in this particular hospital unreconciled discrepancies commonly occurred among anesthesiologists. The hospital lacked Omnicell units inside operating rooms for most of the time, forcing Dr. Kamali and other anesthesiologists to delay returns and wasting in order to prioritize patient care by staying at the patient bedside. Anesthesiologists pulled medications but were then reassigned, so the medications pulled were no longer needed, and even regular staff struggled to use the Omnicell system. These facts do not excuse mistakes, but they do so mitigate these 6 simple departures that the facts do not merit the imposition of probation to protect the public. Our mitigation evidence comes from undisputed facts, some pointed out by the board's own expert. According to the board's own expert, there were no problems with Dr. Kamali's patient care. Dr. Kamali has a 20-plus year history free of complaints. A public reprimand, as proposed by Judge Levy, is a just and appropriate outcome. Thank you.
Thank you, counsel. All right, and from the Deputy Attorney General?
Thank you, Your Honor. Can you all hear me okay? Good afternoon. Thank you for inviting us here today. We are here regarding the board's order of non-adoption of the proposed decision issued by Administrative Law Judge Levy. Specifically, the board has invited argument regarding one particular issue, whether the level of discipline recommended is sufficient to protect the public. Clearly, the answer is no. While the judge, after considering all the evidence, arrived at the proper conclusion, finding the evidence presented established all alleged causes for discipline by clear and convincing evidence, the judge failed to recommend a disciplinary order that sufficiently protects the public by recommending a public reprimand with coursework. At one point in the decision, on page 26, it's an education coursework and a record-keeping course. At the end of his decision, he ordered an ethics course with record-keeping coursework and cost recovery. This recommendation is not only insufficient for public protection, the highest priority of the board, but it is also an extreme departure from the board's disciplinary guidelines, which recommend a minimum of 5 years probation with various terms and conditions. The evidence presented in this case clearly established all 4 causes for discipline alleged. First, that respondent violated state laws regulating controlled substances in violation of Business and Professions Code 2238 and Health and Safety Code 11170, furnishing a controlled substance to himself. Second, that respondent committed repeated negligent acts relating to 6 patients in just his 3 months at Pomona Valley Hospital. And by way of these first 2 causes, he violated provisions of the Medical Practice Act, and he committed general unprofessional conduct. So the question presented today is simply, what discipline is appropriate for public protection? First and foremost, public reprimand is not sufficient. Some amount of probation is necessary, which then raises the obvious follow-up question, how much probation and what terms and conditions are necessary for public protection? But before we get to the second question, I'd like to first explain why probation is necessary. And for that, we must review the underlying conduct and consider the board's disciplinary guidelines. The facts, for the most part, are undisputed, so I won't spend too much time on this, but there are some basics and some highlights I'd like to point out. Respondent was a locum tenens anesthesiologist at Pomona Valley. A few weeks after he started working here, a staff member observed and reported unusual behavior. Specifically, that he requested a tourniquet kit and entered the restroom briefly, then proceeded to a surgery where he seemingly had difficulty starting a line on a patient. This prompted a review of his medication dispensing activities, which involved a review of 3 separate systems: reports from Omnicell, which is the medication dispensing cabinet, the patient records in Cerner, which was the electronic medical record keeping system at Pomona Valley, and BlueSight, which is the audit program that ran in the background to reconcile data and flag concerning patterns of conduct. Initially, nothing abnormal stood out. At that time, he had only been with Pomona Valley for a matter of 3 months or 3 weeks, less than a month. So the pharmacists were asked to continue to monitor his activities. After he worked there for a few more months, the pharmacist reviewing his medication dispensing activity noted unusual behavior, such as pulling medications for cases he wasn't assigned to, pulling medications far in advance of the procedure, pulling medications from Omnicell carts at odd intervals or different times or odd locations in comparison to where the surgery was to be performed, and most significantly, not having all the medications accounted for. When comparing the patient medical records of an administration in Cerner and the Omnicell reports regarding medications dispensed and what was returned or wasted afterwards, there were medications that were not accounted for. So in January, respondent was asked to contact the pharmacy to reconcile these missing medications. When the scheduling didn't match up, he was asked to provide a urine sample. He refused to provide this urine sample because he thought he might test positive for a controlled substance that he had taken that was not prescribed to him, his mother's Vicodin. To his credit, respondent has candidly admitted throughout that he diverted his mother's medication to himself for a migraine. But his refusal to provide a urine sample on that date resulted in his immediate termination from this hospital. These records and reports were then provided to the board's expert, Dr. Amador. He gave an objective review to this case and determined each of the missing medications was a simple departure. He noted there were other unaccounted for medications, but those didn't matter to him. It was the ones that were drugs of abuse that are commonly diverted. Those are opioids and benzodiazepines. According to Dr. Amador, the standard of care requires careful and accurate documentation of these particular controlled substances because they are commonly diverted and abused. So in a nutshell, those are our facts. There's no dispute that he diverted his mother's pain medication to himself. There's no opinion to refute Dr. Amador's opinions and findings. So while they may seem to be separate and distinct issues, they are not. In diverting his mother's Vicodin to himself, respondent admittedly engaged in the exact behavior the hospital was tracking to identify and prevent of this particular class of medications. The standard of care required careful documentation. The whole point is to prevent diversion of these commonly abused controlled substances, which he admittedly did. So at hearing, respondent testified as to what he thinks happened to explain away the missing medications. But he also testified as to each patient specifically that he had no independent recollection. All but one, patient C, who was the patient who canceled a craniotomy, he remembered that incident, but he didn't remember what happened with the medications. So as to each patient alleged, he had no recollection of what happened. I mention this because it's important to distinguish an actual explanation from a possible explanation. When he says he has no independent recollection, but then provides reasons about what happened, it's mere speculation. So as for patient A, we have 2 milligrams of midazolam that was unaccounted for. He says it's possible he probably wasn't able to return it to the Omnicell because he recalls having a few instances with midazolam and a few instances with propofol where the Omnicell unit was not allowing him to return it, so he had to call a pharmacy tech and he gave it to the tech. But again, we don't know that this was this patient. When asked on cross, was that particular to this patient? He could not remember. Patient B, there's 2 milligrams of hydromorphone that was missing. His explanation was that he probably input the number 2 instead of the number 4 when he was wasting the medication, when he was returning or wasting it back to the Omnicell unit. Patient C, we have 2 milligrams of midazolam again. Initially, he testified that he probably didn't enter it correctly, but there's no record of midazolam being returned or wasted, so there wouldn't be a number to be entered. Then he indicated maybe this is one of those times that midazolam didn't appear on the Omnicell unit to allow him to return it or waste it. Again, he doesn't remember. and patient D was 0.5 milligram of hydromorphone. This was a patient with a femur fracture. He indicates there was extreme amounts of pain. So maybe it was administered to the patient while he was waiting for the patient to be admitted to PACU. He testified that he recalls that it took on average 10 minutes to 20 minutes for a patient to be admitted to PACU. And during that time, he was patient focused and trying to maintain their comfort levels. So it wouldn't be abnormal for him to administer these medications while en route or waiting at the PACU to be admitted. He said the same thing for patient E, 250 micrograms of fentanyl. It was a wrist fracture, open reduction, and he was stating probably en route to PACU during those 10 to 20 minutes when we're waiting for them to be admitted. And same again for patient F, 1 milligram of hydromorphone. Again, probably it was administered to the patient while we were waiting for PACU. This is all pure speculation, number one. Number two, we went back over cross to the timelines of how long exactly from the OR to the PACU, and the timelines were no more than 2 minutes for patient D from the OR to admission to PACU. Patient E was 4 minutes between OR and PACU, and patient F was only 5 minutes between the OR and the PACU. So his testimony and recollection about being about 10 to 20 minutes to be admitted into PACU and trying to keep the patient relatively comfortable doesn't hold water when presented with the evidence and the records in the case. This is all pure speculation on his part. This is why we call these possible explanations, but not actually explanations about what happened to the medication. So as briefly as possible, that is the evidence in this case. Undisputedly, he diverted his mother's pain medication to himself, and undisputedly, he failed to accurately document and provide accounting for the medications pertaining to 6 different patients. According to Dr. Amador, each one constituted a simple departure from the standard of care. So next we turn to the medical board's disciplinary guidelines. The guidelines at the beginning talk about, yes, we have to protect the public. Absolutely, that is the highest priority of the board. Where not inconsistent, then a priority is to rehabilitate the licensee. And the board finds, quote, imposition of the discipline set forth in the guidelines will promote uniformity, certainty, fairness, and deterrence, and in turn will further public protection. Absent mitigating or other circumstances such as early acceptance of responsibility, demonstrated willingness to undertake board-ordered rehabilitation, the age of the case, and evidentiary problems, the board, you all expect that the guidelines would be followed. So what discipline is expected per the guidelines for repeated negligent acts and violation of state laws regulating controlled substances? The minimum is 5 years for each, as well as multiple plethora of terms and conditions I'm sure you all are very aware of. So obviously not all the terms are relevant or necessary under these circumstances, so some deviation from the guidelines would be expected. But the judge's recommended PR with education coursework, ethics course, record-keeping course is without sufficient justification. In support of his recommendation, the judge cited a few reasons. First, that he wasn't allowed the time to reconcile his records because he was immediately terminated from the hospital, so he didn't have a chance to go back and look over to see what happened. The pharmacist testified they were always given lists. There's emails in the record regarding lists of different discrepancies that he was supposed to fix. He was talking about them on testimony. He handled some, not all. And the pharmacist explained how simple it was. An email, a text, a phone call, simply saying, oops, I wasted it, sorry, it's not documented, would have been sufficient for them to reconcile the records and close out the matters. That didn't happen. Second, his unfamiliarity with Omnicell. Now, Omnicell is one of 2 most common medication dispensers. Pyxis is the other one, and that is the one that he says he had the most experience with. When pressed on cross-examination, what the difference was between Omnicell and Pyxis was simply the fact that Pyxis provides a printout at the end of each transaction showing what medications are left over or unaccounted for. But Omnicell doesn't provide this printout. That is the only difference. On the user side, when you are holding the rest of your remainder of your medications that need to be returned, I think you don't need a printout to tell you what you still haven't returned or wasted. He admits that he took his mother's Vicodin, so he was given credit for being honest and candid. He was cooperative with the board's investigation, and he has no history of prior discipline. In brief, these reasons cited and relied upon by the judge are insufficient to justify such a grave departure from the guidelines. There's no early acceptance of responsibility. There's no demonstrated willingness to undergo board-ordered rehabilitation. There's no evidentiary issues in this case, and there's minimal mitigation presented. Only 2 character reference letters. None are by physicians. One is an attorney and the other is his brother. A couple coursework certificates and a handful of clean urine drug results. On the other hand, we have several instances in which controlled substances are unaccounted for. We also have a refusal to submit to a urine drug screen at the cost of his job when he admittedly diverted his mother's Vicodin to himself. As such, a disciplinary order imposing probation is necessary for public protection, and a public reprimand is not sufficient under these circumstances to protect the public. Board oversight for some period of time is necessary to ensure the public is protected and will aid in rehabilitation. So how much probation and what conditions are necessary? He's been cooperative and transparent throughout the process. He's provided clean urine drug screens. Some deviation is appropriate. Obviously, not all the recommended terms are necessary or relevant. Thus, it is our recommendation that the board issue an order imposing 3 years probation, education coursework, ethics coursework, record keeping, a practice monitor, solo practice prohibition, and full cost recovery. Thank you for your time. If you have any questions, I'd be happy to answer them.
Council. And then speaking of that, are there any board members who wish to ask any questions of either council at this point? And if so, just identify yourself and state your question. All right, I'm not hearing any questions at this point.
No questions from the board, Your Honor.
All right, so then moving then to closing argument, we have respondent, you have 5 minutes.
Thank you, Your Honor. I would just like to respond to some of the arguments that the Deputy Attorney General has made for the complainant. First, I'd like to say that as a matter of principle, if discipline is excessive, it's more than sufficient, it becomes punitive. And I believe that that's sort of the principle that we're arguing over. It seems to me that the way that the Deputy Attorney General gets, or the complainant gets, I should say, to probation is by questioning the determinations of facts that were made by the administrative law judge based upon the credibility determinations made in the hearing. So in essence, the complainant is asking you to disregard the credibility determinations that were made by the judge and instead substitute your own judgment when you were not able to hear the hearing yourself, where the Administrative Procedure Act mandates that the board show deference to the credibility determinations made by the administrative law judge, logically, because the administrative law judge was in the unique position and had the experience. And of course, these are judges that sit in a medical quality panel. They have a lot of experience with medical board matters to determine the issues and the credibility. And so I think that that is a fundamental flaw and exposes a weakness in the complainant's case. Also, I would ask, since your time is very valuable, it's a large record, there's a lot to look at, that you please look at Exhibit 27, which is the expert's report, and see what the expert focused on. I hear with the Attorney General's arguments a mention of an investigation that was done by the hospital based upon concerns that did not make it into the accusation in terms of those being violations. The simple departures that were found, the violations that were found, were record-keeping errors. It wasn't that someone was carrying medication, when Dr. Kamali is carrying medications, improperly wasting it, or doing things such as that. These are record-keeping violations, and that's what Dr. Amador found, and that's what Exhibit 27 shows, and that's what's in the decision. Refusing to provide a urine sample would be bad, if not that in the same breath, Dr. Kamali said, I don't want to test because it's going to be positive because 3 days earlier, I took a pill of my mother's Vicodin. And he says it right there. And then, okay, let's say that we're suspicious of that. You know, okay, that seems kind of strange. So then a board investigator shows up unannounced. He tests Dr. Kamali, and Dr. Kamali passes that test. And then he says, hey, would you take a voluntary psychiatric and physical exam? Dr. Kamali doesn't have to do that. He says, sure, go ahead, give me your battery of tests. And there is no concern. And then even the Deputy Attorney General in her closing argument in hearing says that the substance abusing guidelines, that those orders are not required in any order of discipline. So there isn't a substance abuse issue, and this is a record-keeping case. So the only thing that makes this, I think, a little tricky, and I'm going to go out on a limb and speculate as to why we might be here, is the board may be looking at this and saying, okay, we have an issue with a diversion of 1 pill of Vicodin, and then we also have 6 simple departures, and it just seems based on the totality of this that a reprimand, it might be too lenient. It might not be sufficient. And so this is the type of thing where if we look back on our history of cases, that we would be, that we would give probation. But there are extraordinary facts here. There's extraordinary mitigating evidence. And that's why the judge made an appropriate decision. Look at the credibility determinations and the facts decided by the judge that a reprimand is the right decision. And Judge Levy decided this correctly. Thank you.
Thank you, Mr. Wright. And lastly, from the Deputy Attorney General.
Thank you. I would like to clarify that we are not here asking you to dismiss what the ALJ's credibility determinations were in the decision. You don't have to dismiss those credibility determinations in order to reach a conclusion that probation is necessary. The testimony of Dr. Amador was found to be very credible, and he gave acknowledgement in his report to the inherent difficulties and challenges faced by not having a uniform standard system statewide, right? So they have, as a locum tenens, they inherently face the challenge of going from one hospital to another hospital and have to work through different types of systems. That's understandable. He testified, respondent, that he was familiar with the electronic medical record system, Cerner, and that he had not used Omnicell. So those are the only 2 devices that we have here that we're talking about. Omnicell, as just mentioned earlier, was essentially the same as Pyxis, which is what he was very familiar using. The pharmacist spoke, Dr. Wang, she spoke about how simple it was, practically like a vending machine. It's so simple. You enter your credentials, you enter the patient's name, and you indicate what medications you're taking, what medications you're returning, and which ones you're wasting. It is as simple as that. They had mentioned about the, I think earlier in the written argument about the complexities that even the hospital had difficulty putting it all back together, but they're putting it back together from the backwards format, right? They're coming from, hey, where did everything come from? And they have to put the pieces back together to see what it is. But from a user end, as an anesthesiologist who's pulling and dispensing medications and returning them, there isn't any of that complexity. So to Dr. Amador's credit, he does acknowledge that these are challenges that anesthesiologists face, and that when they are assigned to different cases, they can be moved around from one OR suite to another OR suite, which may explain why sometimes he would have pulled the medications for one patient, and then he would have to return them all when he's assigned to a different OR suite for a different surgery, correct? But it doesn't explain why only some of the medications would go back. You would think you'd have them all on a tray, you take them all out, and they should all go back. So why are some still missing? So there is that hesitance that I urge you to not disregard, because opposing counsel says he's not a substance abuser, there's no evidence of substance abuse. but there is. He diverted a controlled substance to himself. Does that mean he's a substance abuser? No, it doesn't. But this case does involve a minimal amount of substance abuse. The one thing that they were doing at the hospital, the reason for the tracking, the reason this is a violation of the standard of care is because they're attempting to deter diversion. And yet, in fact, we have an admitted instance of diverting. So it's not unreasonable to say probation is necessary, and it is not required to say that the credibility determinations by the judge in his decision need to be tossed out the window. You can accept all those credibility determinations. If you read the transcripts, and I urge you to, he did testify very honestly and admitted he had no independent recollection. He's just trying to put it back together himself. What happened to the medications? We don't know, but we do know they're not accounted for, and those are simple departures from the standard of care. So protection of the public is always the highest priority of the board. The facts and circumstances of this case are undisputed, abundantly clear, in fact. He admitted to helping himself to his mother's pain medications, and the only expert opinion before the board is Dr. Amador's, who testified clearly and credibly. The hospital put in place measures to track these particular medications to identify and track potential diversion, which is why the pharmacists were tasked with the long-term review of his cases. They weren't simply identifying cases that had missing medications. They were identifying all patterns of conduct for what single purpose is that they're all looking for diversion because this is a problem. When they requested urine, this is when he declined, and he admitted, in fact, he diverted his mother's medication to himself. So logically, it follows that probation is necessary and appropriate discipline in this case to protect the public. He admittedly engaged in the exact behavior the hospital was trying to prevent, and by not keeping solid or clear account of all the medications he was pulling from this dispenser, he failed to meet the standard of care. And it wasn't just a singular attempt. It was 6 different patients over 3 months while he was there. It wasn't just 6 patients at the very beginning when he started. It's 6 patients from October, November, and December. As the board guidelines indicate, applying the guidelines will consistently, in a consistent way, will help to deter future violations. And in turn, that does promote public protection. So by imposing probation, this allows the board the oversight necessary to ensure the public is protected. Thank you.
Thank you. All right. And then based on those closing arguments, were there any questions for either counsel?
None, Your Honor.
All right. And I can offer respondent the opportunity to address the panel. Counsel, does your client wish to address the panel?
Yes, Your Honor.
Right, and then there we go. I just need to be able to see him so I can swear you in. All right, doctor, if you could please raise your right hand and be sworn in as a witness. Do you solemnly swear the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, and what did you want to tell the panel today, doctor?
Thank you. I wanted to thank the board for giving me the opportunity to speak today. Growing up, I always enjoyed the opportunity to help others, and this is why I pursued career in medicine. I was fortunate to secure a position in my residency of choice at Bethesda Deaconess Medical Center in Boston, the teaching hospital of Harvard Medical School. As a resident, I was elected to be one of 2 residents to take on the responsibility of being chief resident in anesthesiology in my last year of training. One of the reasons that I was elected as chief resident was when it comes to practicing medicine, I made sure that I was very vigilant when it came to patient care. This is something that I've continued to do in private practice over the last 20 plus years. Upholding this work ethic while in private practice, I have never had any complaints or adverse outcomes while providing anesthesia. I thank the board for taking into consideration that during my 15 weeks as a locum anesthesiologist at Pomona, I was working on a 2 weeks on, 2 weeks off rotation while providing care for my sick mother, which did not affect my patient care, but did regularly impact my reconciliation of medication dispensing records. While I do realize in a perfect world we would never have any discrepancies, I have always made sure my main priority has always been patient care. I do understand that I need to be more vigilant going forward with my documentation, as I understand the great importance of upholding the safe and responsible management of medication used in patient care. While growing up, I was always taught that I should take responsibility for my actions, whether those decisions are positive or negative. When I took my mother's medication, I did so because I was in severe pain, and at the time, our health system was overwhelmed with the COVID epidemic. So I did not want to expose myself or my family members by going to the ER. In hindsight, this was a lapse of my professional decision-making that happened while I was helping to take care of my mom due to her health issues. So I understand the board's concern and want to assure the board that this is an isolated case and that it has never otherwise happened or will never happen again. I have been constantly open, honest, and forthright with the hospital, your board investigator, the administrative judge, and this board about taking that one pill of my mother's medication. I have done this because trust and good judgment are so important in this profession. Thank you.
Thank you, Doctor. Just a reminder that while respondent did provide a statement that may have noted some matters outside the record, the decision must be based only on the existing record and the evidence admitted at hearing. All right, I believe that concludes the arguments in this matter. So the record is closed. The case is submitted for decision and we are off the record. And then I believe now the panel will be deliberating in closed session.
Thank you, Your Honor.
And Judge, if you need any information from the court reporter, now would be the time before we adjourn for the closed session.
And actually, Madam Court Reporter, is I believe that the Attorney General's office had ordered the court reporter, is that correct? So the info goes to them, or?
Yes, that's my understanding. I have them on the worksheet, but did you want start and finish times and page estimates?
Yes,
Or-
please.
Okay, so do you want to take them separately? The first one, the end time was 2:17 with 42 pages. And then the second one, the finish time was 3:07, also with 42 pages.
All right, thank you so much. I do have your CSR number and your name, so I think we have all the information. Did you have any spelling questions from?
Thank you, Your Honor. No, I think I'm okay. I have everything.
All right, wonderful. Thank you very much, Madam Court Reporter.
Your Honor, thank you. Thank you, everyone.
And Judge will be clearing the room and joining the closed session. We sent an invite to you as well. Do you have that invite?
I believe I do. I have something pending at the bottom, so I'll just go into that meeting room.
Yes, you can go ahead and leave this one and we'll meet you over there in just a few minutes.
Thank you so much.
Thank you. Actually, Judge, I'm
Yes?
sorry, that's not true. I need to send you a separate invite. I just realized
Does
because we
anybody
have
on the board
that
need a break?
council on the
You guys fine? You need 3 minutes? You okay, Doctor?
Please wait
We're
for
okay. Fine.
a new update. I'll send you an invite right now. I apologize about that.
Okay, no problem. So the closed session link that you sent the other day is not correct then?
No, sorry. Let me send you a correct one.
Okay.
Because we have actual DAG staff in there that we can't have in there for the closed session. I'm just posting the closed slide here and I'll send you another invite in just a second. I'm sorry.
Okay, perfect. You know what, let me open up notes on.
If you just Okay, so that email should be on its way, Judge, and as soon as you get that, you can go ahead and leave this meeting. We'll meet you.
Thank you. And it always takes a while for emails to get through the system, unfortunately. What time did it get sent through? I'm just going to look through.
I should have just been a minute ago. I literally just created it. If you want to, well, it should have came through to your inbox like the other one did. It possibly could have gone to your junk. You could search
Oh,
for
let me just look and see.
Messenger at webex.com.
There was at 2:46 there was a messenger at WebEx. Is that the one that you're talking about?
That's probably the incorrect one. This one will be
Okay.
labeled Panel A Private.
Ah, okay, as opposed to closed session. Okay. So I'm still not getting it, but I will. What email address did you send it to, if you don't mind?
I don't want to say it since we're still
Right.
live in the public session, but the same one I sent the earlier one to. I'm gonna go ahead
Okay.
and send a email as myself now, just in case there's a problem with the WebEx one getting through here. Give me just one.
Hold on. 3:15. All right. It finally came through.
Fantastic. Okay, so yeah, if you just go ahead and exit this one, join that one, we'll see you right.
Okay. All right. Thank you so much.
Thank you. And to all the public attendees still in this meeting, you can wait. We will return to adjourn. But other than adjournment, there's nothing left on the agenda. So thank you very much, and we'll be back after closed session.
Yes, Eichelkraut, this is the court reporter. You don't need me again today, right?
No, that's all for today. Thank you so much.
Awesome. Thank you. Okay. See you again
Have a
next
good
time.
afternoon.
You too. Thanks.
This is Panel A of the Medical Board of California, November 20th, 2024, adjourning our meeting at 4:59 p.m.